Hello, everyone. Today's June 18th, 2025. The meeting is now open at 4:01 p.m. A copy of the Nebraska Open Meetings Act is located on the north wall of the county boardroom. We'll do a roll call now. Davidson?
Present.
Bennett?
Here.
Bruce? And I'm Kimmerling. And Gifford?
Here.
Also attending, Carrie Plummer-Galecki, Board Secretary and Assistant HR Director Jody Riddell, and is the HR Director. Carrie, do we have anyone wanting to speak during the open comments portion of the meeting?
No, we did not.
All right. With that, we will move to item 2. Item 2 is to approve the minutes of the May 21st, 2025 meeting. Do we have a motion to approve?
A motion to approve with amendment. Diane Bruce is not present.
Okay. Motion to approve with the amendment at the top of the meeting minutes under members attending. Diane Bruce should be listed under board members absent. So motion by Davidson to approve with the amendment. Do we have a second?
I will second.
All right. Was that Gifford or Bennett? I'm so sorry.
Bennett.
Oh, Bennett. Wonderful. Second by Bennett. Please vote. Are we ready to vote, Carrie? I don't see anything popping up. Oh,
Is it?
there it is.
Let go now. Okay.
It went now, yep.
4 yea, 1 absent. Motion carries.
Okay. With that, we will move to item 3, discuss and make recommendations to Sarpy County Animals in the Workplace. Jody Riddell, HR Director.
Hi, good afternoon. So the policy you have in front of you is a new policy that basically states the only animals allowed in the workplace are going to be those that are service animals or therapy animals, our facility dog that we have over in the courthouse. So that's simply what this policy lays out. And then it discusses the expectations of an animal in the workplace.
The only question I have is under section 1, number B, in general, a service animal, so on and so forth. So are you requiring the animal to be a trained and approved service animal, or just that the person has the appropriate documentation to need a specific animal? Does that make sense? Some of them have actually gone through training and passed and are official, and some of them are just animals that people have that they get recommendations, for an accommodation. Do you have any position on whether they have to be an official service animal? Does that make sense?
For this one, it says a service animal. So, and then if we go further down, we talk about therapy animals and the facility. So we could put a service animal or a trained therapy animal, because we can further down discuss that, just to make it a little clearer.
Yeah, and I don't know if it necessarily needs to be in the policy, but there may be a difference in whether you would, the level of training that an animal had gone through.
Okay, I can add that, no problem.
I don't think it's huge for in the policy, but just something that people might ask about. Were you contacted by anyone to request to make comments on this policy?
No.
Any discussion from the board? Okay. No one requested to appear before the board and give their views on the proposed rule. Therefore, no comment period was provided. Do we have a motion?
I'll move to accept this with the change in clarifying what the service animal is.
Okay, second.
I second.
Okay. Motion by Bennett, second by Davidson to approve the Sarpy County Animals in the Workplace policy with an amendment to clarify service or therapy animal with those changes.
For yea, 1 absent. Motion carries.
Okay. Item 4, discuss and make recommendations to updated Sarpy County reasonable accommodations policy. Jody again?
Yes, so this is the updated policy that we discussed at the previous policy board meeting. We made a couple of updates to note very specifically that the employee may be asked to sign a limited release with specific questions directly related to the reasonable accommodation. And then we use the exact same language on how that information will be handled from the FMLA so that the policies are consistent across. So those edits are in Section 3 and Section 4 alpha.
Great. Do we have any discussion on those changes, or do we feel like those meet the, okay, great. Jody, were you contacted by anyone to request to make comments?
No.
Okay. No one requested to appear before the board and give their views on the proposed rule. Therefore, no comment period was provided. Do we have a motion?
I move to approve as recommended.
A second?
I'll second.
Okay. Motion by Davidson, second by Bennett, correct?
Three yea, one absent, motion carries.
At this time, I'd like to ask for a motion to officially move into a grievance hearing.
I'll make a motion to move into the grievance hearing.
And a second?
I'll second it.
All right, motion by Bennett, second by Gifford to officially move into the grievance hearing.
Okay, good afternoon, ladies and gentlemen. Today, the Personnel Policy Board of Sarpy County is conducting a hearing on the grievance by the Sarpy County Treasurer's Office employees.
I still need Melissa and Jonathan's vote.
Oh,
Sorry.
that's okay.
Very
Sorry, I couldn't see that.
You're fine. Four yea, one absent, motion carries.
Take two. Good afternoon, ladies and gentlemen. Today, the Personnel Policy Board of Sarpy County is conducting a hearing on the grievance filed by employees within the Sarpy County Treasurer's Office. Counsel, would you enter your appearance? We'll start with you.
Yes, Ryan Kuhnhart, the board advisor on behalf of Sarpy County, and with me is Jane Coles from law firms.
Thank you, Mr. Kuhnhart.
Good afternoon, I'm John Corrigan, the Dowd Corrigan Law Firm, and I'm representing grievance, the Sarpy County Public Employees Association.
Thank you, Mr. Corrigan. The Personnel Policy Board Hearing Regulations 5 provides a formal procedure for today's hearing, unless the parties have agreed otherwise. Have there been any agreements otherwise?
Not to go outside the policy procedures.
Okay. So, Mr. Kuhnhart, you have a chance for an opening statement, which should be limited to 5 minutes or less.
Okay.
Yep.
Thank you.
I would clarify that in a contract dispute, the grievant has the burden of proof, the burden of going forward as opposed to the employer. And so typically that would be that the grievant would go first and the employer would go second. But if you want to go out on a different route, that's fine with me too.
I'm fine with that.
I don't have any issues with that either.
Okay.
Yeah.
Okay, Mr. Corrigan, go ahead.
Not that I want the heavy oar, but to be honest with everybody, we have it in this case. So thank you. And thank you. This is simply a dispute between the union, employees that are covered by the union in the treasurer's office and the county and the treasurer over whether the employees should have been paid for a day that the treasurer told them that the offices were closed. On March 19th, if you recall, we had some really bad weather in this community, and the treasurer, I think, will testify, and the exhibits will establish that they decided to close the office and told the employees, we'll see you tomorrow. And thereafter, the treasurer advised those employees that they were going to have to take their own time off because the county board, through the county chair, the chair of the county board, did not declare the county offices would be closed on the day in question. The employees will demonstrate they filed grievances. The treasurer initially sustained the grievances and said, you know what, you're right, I think you should get paid. And then later changed his mind and said, I'm withdrawing my decision to approve your grievance. The union then filed a grievance to this board, I believe on the 1st of May, with an email from me, along with a number of grievances of the named individuals. It's our position that there's any order of the commission should apply to all employees of the treasurer's office, because when the union filed the appeal to the board, we said we wanted a make whole relief for all employees who had to use leave that day. They weren't named in the grievance. If the county board, or I'm sorry, if the personnel policy board determines, well, if we don't have a named grievance filed by that employee, we're not going to order any remedy for those people. We'll live with that, but we don't think that that's fair, nor is it necessarily consistent with the grievance that the union filed. But be that as it may, I want to bring that to your attention, as it may be an issue. Essentially, the union's argument is the board and the elected official have both have management rights and prerogatives in determining the terms and conditions of employment. And both of those entities combined to negotiate a collective bargaining agreement with the Sarpy County Public Employees Association, and part of that contract says that the elected official determines the start time and stop time of each workday. It also says that they have certain management rights. And the union's position is if they're told don't come to work today, not because the county board said it was a bad day, but because their boss said it was a bad day, then under the contract, they should be paid. And if the county wants to have a rule that says that the elected official can't do that, they need to negotiate that into the contract. And it's just that simple. And so hopefully we'll be able to streamline a little bit of this evidence today. But with that, I will wait for the opening, and we'll offer you some evidence and present the case to you. Thank you.
Thank you, Mr. Corrigan. Mr. Kuhnhart?
Yes. Thank you. And I mean, what we are talking about here this afternoon is the interpretation of the county's inclement weather closure and emergency declaration policy. And under that policy, it's clear that the only individual who has the ability to close the county or shut down the county in the event of an inclement or severe weather day is the county board chair. That did not happen here. So what happens in those situations is employees have to use accrued leave or PTO if the county board chair does not close the county. On March 19th, the county board chair did not close the county. So under the policy, any employees are required to use accrued PTO or leave. From the county's position, that's the sole, very simple issue here today. Council did bring up the fact that it's his belief that all employees should be granted relief today. We disagree with that position. The evidence is going to show that 8 individuals filed grievances. Not everyone did. Everyone had the opportunity to. And if you look at Article 24 of the union contract, it talks about how employees choosing to file a grievance are to complete a grievance form, and that aggrieved employees shall present the grievance form to their elected official within 15 calendar days. Only 8 individuals did that. So first of all, again, it's our position that the grievance should be denied, as the county was not closed by the county board chair. Therefore, the employees were not entitled to pay and had to use PTO. If the board is not inclined to accept that argument and is inclined to grant the relief that Mr. Corrigan is requesting, it should be limited to only those 8 individuals that filed the grievance. And so with that, I think we do have a stipulation, John. I don't want to address that.
I'll go ahead and offer our exhibits and then address the stipulation once you've offered your exhibits, and then we'll start.
Okay, that sounds good.
At this time, if I may, I just want to go ahead and offer the union's exhibits A through J. A being the collective bargaining agreement, B being the inclement weather policy in effect at the time that this incident took place, C being the Rule 12 of the Personnel Rules and Regulations regarding leave, types of leave, D being some text messages that we will get into, E being an email of Jeff Miskell, County Treasurer, dated 3/20/25, F being an email of Mr. Miskell dated 3/28/2025, G being the appeal of the union and a 4/16/2025 email from Mr. Miskell, H being the grievance forms that were presented with the appeal, to the board. I being a county board resolution declaring an emergency as a result of the weather experienced on 3/19/2025. And J is a proposed policy change regarding the inclement weather policy. And we'd offer those at this time.
Mr. Kuhnhart, any objection?
Our only objections are to exhibits I and J. I specifically on relevance. This resolution was after the fact and has nothing to do with the decision to close the treasurer's office on the 19th. And then J, we also do not think is relevant. J is a red line of a proposed revision to the policy. It's not the policy that we're here talking about today, so it has absolutely no relevance on the hearing before the board today.
I think we're going to find that today's hearing is pretty informal when it comes to relevance. So it's my recommendation that
Can I respond to that?
you sure can.
Okay.
Briefly, please.
Yeah, just with respect to the evidentiary objections, the rules of evidence do not apply to this hearing. And we recognize that too. And that's one of the reasons I didn't object to the exhibits offered by the county. But also, it's really up to the board itself to make a determination about the weight to give a particular evidence, whether it's relevant or not, or whether it informs the decision. The two exhibits that they've objected to, the relevance is, one, on just with regard to the county board resolution, the union's argument on relevance would be just the severity of the nature of the weather event was so severe that the county board itself declared an emergency in order to get emergency funds for the response. J, relevant because it is a after-the-fact action on the part of the county to address what the union believes to be the language deficiencies in the policy itself.
So, Mr. Corrigan, just one moment. Mr. Kuhnhart, because it's more relaxed and the rules of evidence are going to be a little bit broader, would you be willing to withdraw your objection?
Yes.
Okay, just in the time of not having
That's
to go
fine.
through a vote, that would be helpful. I appreciate that. So the Personnel Policy Board will accept exhibits A through J into evidence. Thank you. You mentioned that there was going to be an issue that we discussed after this, after the evidence. Do you want to admit yours in now?
Do you want to offer? That's
Your-
right. Yeah.
You want to offer all of your exhibits?
Sure, I can do
And
that.
that would be exhibits, you don't have to go through them, but exhibits 1 through 19, I believe?
Well, I had 1 through 19, but I believe in a discussion with Mr. Corrigan, Austin, I think it's Junk, will not be pursuing the grievance. Is that correct?
The union would concede that as a probationary employee, he's not capable of pursuing a non-disciplinary grievance.
Could you repeat, or could you spell his last name for the record?
Yes. Sorry. Johnk.
Okay.
And the reason I mention that is with that understanding, we will not be offering exhibits 4 and 5. So we would offer exhibits 1, 2, 3, and then exhibits 6 through 19.
So not offered is exhibits 3 through 4,
Not offering 4 and 5.
4 and 5. Thank you. Mr. Corrigan, do you have any objection to those exhibits?
No.
Okay. So those exhibits will be deemed admitted. Mr. Corrigan?
And the parties have submitted a stipulation to the clerk for, that's been signed off, but I'll just give you a copy of it. This is an unsigned copy of the stipulation that we've entered on the record in an effort to streamline the time. And the stipulation it commemorates the agreement that if called to testify, the grievance, Rose, Hesterberg, Montez, Smith, Turnbull, Miners, Wentworth, and Sempeck would testify that they had not been had they not been notified that the office of the Sarpy County Treasurer was closed due to inclement weather on March 19, 2025, they would have come to work and would have had not been forced to use accrued leave to remain in paid status on that date, and that if called to testify, each of those aforementioned would also confirm that they acknowledged that they read, understood, and agreed to abide by the existing collective bargaining agreement, Sarpy County personnel rules and regulations, harassment and discrimination policy, and the IS security policy upon accepting employment with Sarpy County, and they acknowledge that it is their obligation to keep current on said policies. And with that, I'd be happy to call our first witness.
Non-signed copy.
I do have a signed copy. Yep, I do have a signed copy by the both council, and I'll place that in our file. Yep. Okay, Mr. Corrigan, go ahead and present your case.
We call Sarpy County Treasurer Jeff Miskell.
And Mr. Fiscal, you can come right over to around to that side there, so you can sit down. Yep.
Yeah, I'm sorry. I was wondering the same thing.
So you know we're in a horrible time here back here.
Okay.
Would you please state your full name?
Good afternoon. Jeff Mikesell, Sarpy County Treasurer.
Great. And would you please raise your right hand? Do you affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good afternoon, sir. Is it, you pronounce your name Mikesell?
Mikesell.
Mikesell, I'm sorry.
It's okay.
And my understanding is you were appointed to the position of Sarpy County Treasurer, correct?
Correct.
When were you appointed?
On or about 13 September 23.
And since that time, have you sat for election to that office?
No.
And there are a number of people in your office who are holding classifications that are covered by the Sarpy County Public Employees Association, correct?
Yes.
And just so, there was one thing that was said during the opening, I want to make sure, see if you understand the facts very clearly, but essentially, the office was closed on March 19th because there was bad weather, and that was the judgment that you made, right?
Correct.
About how many people do you, are in your office under your supervision?
There's a total of 29 in our office.
And of those, how many would be covered by the union, if you know?
Fair question. I should know that better. 20, 22?
Okay. And is it also true that more than just these 8 individuals filed grievances with you initially in order to challenge the decision that they were not going to have paid time off during the 19th of March?
That's correct.
So it wasn't just these 8.
Correct.
Do you know how many it was?
19, 20, in that range.
Okay. And would that also be consistent with actually the number of people who are in the bargaining unit that are also in your office and represented by the Sarpy County Public Employees Association?
Given my recollection of both of those things, yes.
Okay. I'm going to ask you to, if you can go to Exhibit D in that notebook.
Or
Exhibit D.
I just have numbers.
The back, farther back.
Okay.
Yeah. Mr. Miskel, I want to remind you that it's important that you speak into the mic. We're just having a hard time picking up your voice. Thank
I
you.
understand. Yes.
Do you have that Exhibit D?
Saying Bravo or Delta?
D is in Delta.
Yes, I have it right here.
Okay. Now, this, my understanding, this is a text message chain that went out around the 5th of March of 2025. And it indicates that you sent out a text message at about 5:30 in the morning to a group of people to determine what time the office would open rather than the normal starting time.
Correct.
All right. Can you walk us through what happened on the 5th of March?
Overnight, had a significant snow. It tapered off toward the end, but there was significant accumulation of snow. I went to the office and determined that the sidewalks weren't clear. The parking lot was not yet cleared, wasn't ready for business, but the skies were clearing, the storm was ending, and it made sense that, well, in a couple hours, we can have this stuff cleared out and we can be open for business.
And so if you look at page 2, well, I'm sorry, at page 1, you indicated, I'm thinking we say 10 o'clock open. And then you indicated Jason is emailing the county with the 10 o'clock open decision, right?
Correct.
So that was a decision you made to open at 10 rather than 8 o'clock.
Correct.
Did the county tell you that you can't make that decision?
No, there's more to that story, but no, not at that time.
Okay. We're all ears. If you want to tell us the rest of the story.
I'm sure we're going to get to it. There's 2 other events here within 10 days, 2 weeks. This first one, the decision for the treasurer's office to open at 10 was preempted by the county because at or around 6:14, they decided to have a late opening of 10 o'clock also. For the later one,
Well, let me ask you this. On the 5th, the employees a communication went out to employees from your office that there was a 10 o'clock opening, correct? There wasn't any communication that went to them from the county board. It was from you.
correct.
All right. And if you look at page 2, there's a text message where you put in the screenshot of the Sarpy County weather notice. You see that?
I do.
And was that the sort of preemptive thing that happened with the county board announced that there was going to be a closure?
Correct. It was just minutes, 20 minutes. I don't have the exact times after our text of decision to open at 10 went out.
And did you send the second notice out to the employees?
There's a lot of things I remember. I don't remember the specific on that very one. Either I found this on the website or it was sent to me by either Mary or Jason, and then that was shared with the group as well down the line from me.
Okay. Now, if we go forward to page 5 in that Exhibit D.
Timestamp 8:35 at the top left.
Yes.
Okay, got it.
There's an entry that says Douglas County closed, and then at 5:10 a.m., your text message, text your people, we are closed for the day. Was that your announcement to your employees that on the 19th of March, your office would not be open?
Correct. We have a chain email. I notify 2 or 3 folks, and they in turn notify those who they're directly supervising.
With the concept that everybody's going to hear that?
Exactly.
Okay. And your statement at that time was have a safe day, everyone, see you Thursday AM. So the 19th was a Wednesday, and you were indicating that we'd see you the next day, right?
We fully expected conditions to be supportive of business that next day. Yes.
All right. And the next Exhibit E in that booklet, if you would go to that.
Weather day outcome email.
Yeah, and that's dated March 20th, and that's to the treasurer group. Do you know roughly who that comprises, the group?
Treasurer group is everybody in the office.
and you stated that on the 20th, that your efforts with the board and HR to cover yesterday with admin hours was unsuccessful. Can you describe for me what you did in that regard?
Had a meeting with admin and one board member describing the intended procedures and process for closing the county. I can close the office, but that's probably not the best way to do it. That's what we decided. The mantra coming out of that meeting was the county will never close. It will be incumbent upon each individual employee whether they want to come in and burn their PTO hours. My concern overall on both of these events was safety of the employees. That was my only consideration.
Well, you said that you can close the office. What did you mean by that?
I'm not restricted from closing the office, but PTO hours will be required to cover those that day or the time of the closure.
So your understanding is if you close the office, employees don't get paid, but if the county board closes the office, then they may get paid.
No, current policy is PTO hours across the board.
So if the county closes for a weather event, employees aren't paid for that time?
I understand PTO hours are required.
Okay. Was that your understanding?
If I close the office, it's PTO hours.
Okay.
If the county closes, then it's covered. And that's with different contracts and different agencies that they have concerns about. I misspoke. You are correct.
All right. So you went to the county, or to this one board member in HR, and wanted these folks, your folks, to be paid administrative time for that closure.
I inquired as to the possibility. A little history, if I may. I had asked to put on a board agenda item that we have 16 hours of weather time allocated per year to be used at the discretion of the department head, elected official, and I was unsuccessful to get that in front of the board.
When did you have that effort?
Oh, shoot. About a year ago.
The email in Exhibit E that you sent out, you indicated to the employees that they had an option to earn comp time for future use. Does that mean that they could work more than an 8-hour day and or more than 40 hours in a week, and those hours could be billed up to recover the hours that they had to use as a result of this dispute?
Correct. Come in a little early, do some paperwork, get more prep done, that sort of thing.
Okay. Now I'm going to ask you to go to Exhibit F. In this email dated March 28th, you communicated to the employees of the Treasurer Group that moving forward, you said you will not close the office for any weather event, but the employees would have the option to choose to come to work or use PTO and stay home, right?
Correct. I wanted to ensure clarity across the office.
But that was something, that wasn't what you communicated to them on the 19th of March.
Not verbatim, no.
You just told them, we're closed today, see you tomorrow.
Yes, sir.
All right. Now, if you go forward to Exhibit H, as in Harry. So just the first page is the grievance of Adriana Rose.
Mm-hmm.
And it's dated April 3rd. But you would agree that you received grievances similar to this from every employee covered by the union contract, if not all of them, most of them.
Correct.
And your response to the grievance on April 3rd of 2025 was to accept the remedy proposed by the employee, which is to receive admin leave for the vacation time they were required to take.
Yes.
And that was true for all the folks that filed those grievances.
Yes.
Can you tell us why you thought that grievance should be, or that remedy was appropriate at that time?
This is roughly a week after the previous email. Folks had time to think about it. I was approached by one employee initially. We spoke about it in the office, and then 3 folks came in and talked to me about it, and it rapidly escalated from there. I wanted to support my people, and that's why I took the action here. As you can see, I wrote.
Now, if we go back, I'm sorry I tried to put these in order, but if we go back to Exhibit G. In the middle of that document, there's a April 16th, 2025 email from you to Angie Smith, and she's one of the grievance, right?
Yes.
That you stated, upon further review, I have decided to withdraw my previous response and deny your grievance for the March 19, 2025 office closure. What happened between the 3rd of April and the 16th of April that changed your mind?
I had contact with a board member, county admin, and county HR, and we determined that this was not the process to change policy, and I should not be in support of that. We should work it a different way.
Okay.
Which brings us here today.
And the grievances, those emails that you sent, those went to all the people that filed the grievances, right?
Yes.
Now, if your employees are part of the group, whatever they, if it's either through a text chain or email group, and for the treasurer's office, and they're advised, we're closed due to inclement weather today, how are they supposed to know whether that's an order of the board or an order of the elected official?
That's a fair question. I'd have to speculate how it would have been. The 10 o'clock late closure, that was obviously for me, because I identified it that way. The second one had an actual, I'm making a square here on the website with that announcement that we sent out to everyone. So for the second one, they knew it was county.
But on the 5th, there was one note that went out saying we're closed. It was you.
Yes.
And then maybe minutes later, there was the website screenshot saying that the county was closed, and that also was sent out by you.
It was either me or Jason or Mary. I honestly don't recall exactly who did the
But it was your intention that it be sent out to the employees.
Yes.
And on the 19th, a notice went out from you.
Right.
Do the employees have an obligation to go find out whether that's real or not, or to ask the board if they've made a decision along those lines?
Don't have an answer to that one. I think that would be a personal choice, but if you're getting notification from your boss, I would think that would be adequate.
Well, if it wasn't about an inclement weather situation, and it was about I want you to come to work today, that probably would be something you would expect them to respond to, right?
Sure.
Okay, those are the questions I have. Thank you very much.
He's one of my witnesses.
You want
Can
to
I-
call in and then,
Well, do you want me to ask my questions now, or we can wait?
let's wait.
Wait. Okay.
Yep. Thank you, Mr. Miskell. You'll be called back, so please don't leave.
Terrific.
Mr. Corrigan, you have another witness?
I would have no objection if he wants to ask a question. I mean, I don't see any point in
Okay.
recalling him.
That's
You're okay with it?
Yeah.
All right, we'll go ahead and, in the sake of keeping it efficient, if you would please, you're still under oath. Mr. Kuhnhart's going to ask you some questions as we go forward here.
So I'll just ask my questions and you'll be done. Okay. All right. Let's take a look at a couple of the exhibits in the binder. So if you go to Exhibit 1. This is the policy that we're here talking about today, correct?
Yes.
Okay. And under the policy, who has the authority to close the county? All right, I'll ask a better
As
question.
determined by the county board chair.
Okay. In the event of a severe inclement weather.
Yes.
Okay.
That's B1.
What was that?
Yeah, B1, the reference.
And that did not happen on March 19th, correct?
Correct.
And I think you said you closed, when Mr. Corrigan was asking you questions, you closed the office due to the safety issues?
Correct. Safety of the employees was my concern.
Were you aware of this policy, meaning Exhibit 1, when you closed the office?
Yes.
And were you aware that your employees would have to use accrued time or PTO?
Yes.
And did your employees have any expectation of getting paid for that March 19th weather day?
I would think not.
Why is that?
That's not policy.
I want to ask a couple of questions, clarifying questions to Mr. Corrigan's questions. Let's go to Exhibit D. And if you'd flip to the second page in Exhibit D, you see that screenshot?
Yes.
Okay. So on March, I believe it was March 5th, the county declared a closure, correct?
Yes.
Or I should say a 2-hour delay. Is that correct?
From 8 to 10, correct.
Okay. And were your employees paid for those 2 hours?
Yes.
And why was that?
That's admin time covered by a county function of closing.
Because the county closed.
Correct.
Okay. Flip to Exhibit G. And we looked at that email that you sent to Angie Smith on April 16th of 2025. Do you see that email?
I do.
In the middle of the page?
Yes.
Okay. And you sent that email to everyone that filed a grievance, is that correct?
Yes.
And is that email, what you said in that email, is that consistent with the policy that we looked at Exhibit 1?
Yes.
Okay. Let's take a quick look at Exhibit F. If you go to the second paragraph in Exhibit F that starts with also, do you see that?
I do.
Okay. You gave your employees the opportunity to earn back that eight hours of accrued time after the March 19th
Yes.
weather incident, correct?
Yes, sir.
And why'd you do that?
To give them the opportunity to make it up so they're not in a hole for their vacation time. A lot of folks are kind of tight and they have vacation plans and such, and I didn't want that to impact. So if they could come in 60, 45, 30 minutes early, they would be afforded to do admin work, set up, prep, whatever's needed for their section to make up those hours.
Okay. I have no further questions for this witness.
Thank you. Mr. Corrigan?
Can I redirect?
Yep.
just on that last point, folks are tight. They might have childcare issues or their own health care, or maybe it's parent care issues
A myriad of issues.
but they were given the opportunity to come in and work more so they could make up the time that they lost when they were told not to come in on the 19th.
Yes.
And with respect to the policy, if you can look to Exhibit B. Just looking at under paragraph B2. The policy says the county board chair shall have the discretion and authority to implement severe inclement weather closure, right?
You're A2?
B2.
I'm sorry, B2. Yes.
And do you think that that excludes your ability to close your office? It doesn't say you can't do it, it just says they have the authority to do that.
They have the authority to close the county. Yes.
But it doesn't say you don't have the authority to close your office, does it?
Correct.
Now, if you go to page 2 of that exhibit, paragraph 5 says, if county offices are closed due to severe inclement weather, the following pay procedures shall apply. And paragraph B says employees that are not required to report shall be paid for the inclement weather closure period at their regular hourly rate, correct?
Yes.
So your office was closed at your discretion in your county office, right?
I am a county office.
You're a person appointed to an elected official's position.
Yeah.
But your position is today, it would be inappropriate for those folks, even though that county office was closed, to receive their pay at their regularly hourly rate because it was your decision to close it rather than the board's.
Yes.
I don't have any other questions. Thank you.
No further questions?
Nothing further.
Okay. Thank you, Mr. Miskell. Mr. Corrigan, do you have another witness?
Yes, we call Sharona Ernst.
Hi, would you please state your full name?
Sharona Ernst.
And what is your position within the county?
I am a Sarpy County Diversion Officer and a representative on the board for the Sarpy County Public Employees Association.
And would you please raise your right hand? Do you affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Thank you. Sharona, in your role with the Sarpy County Public Employees Association, do you participate in the negotiation of the collective bargaining agreement?
Yes.
And if you have the notebook in front of you, you have Exhibit A, that's just the contract.
Yes.
Article 4, I'm sorry, on page 4, Article 2 of the contract indicates that the association is recognized as the bargaining agent for certain employees, both of the county and different county elected officials, right?
Yes.
And the treasurer's office is one area where you have employees that are covered by this contract, right?
Yes.
And you don't work for the treasurer, you don't have anything to do with their office,
I do not.
other than negotiate wages and terms and conditions of employment.
Correct.
And the county, in their contract with you under Article 3, they reserved certain rights to the management, both to the county and elected officials, right?
Yes.
And one of those rights under Section 2C of the contract at page 5 was the right to
Establish, allocate, schedule, assign, modify, change, and discontinue county operations and work shifts, so long as changes in day off shifts and working hours other than in emergencies, which shall include but not be limited to unplanned absences, are made only after the order for such change has been posted for 7 calendar days. Except in instances which affect a single work crew or a single employee, the county and/or elected official will make a good faith attempt to deliver such notice.
and the elected official under Article 9 establishes the start and stop time regarding the hours of work, right?
Employee shall report to work at a starting time and leave work at a quitting time as determined by the elected official.
So what is it, the position of the union with respect to the county determining that these folks who were told not to come to work because of a inclement weather event shouldn't be paid, even though they were the office was closed by the elected official as opposed to the board making that closure?
So the elected official, per our contract, has the ability to set our work schedule and hours. And if the elected official is closing the office for inclement weather, I would read that in the inclement weather policy, the office is closed, we get paid time for office closure.
And prior to this, have you ever had a dispute like this before?
I've had several, anytime the weather starts to get bad, lots of questions regarding the inclement weather policy. Because the wording is not very clear. And so in figuring out, some departments don't understand, who is
Essential. And
essential employees or not, right? And so people not knowing, am I essential, am I not? And then, if it is a 2-hour closure, do I either have to come to work or have to use vacation time, or is it that it's a too late start and they pay the 2-hour late start? So there was tons of confusion, and it was being implemented, from my understanding, different ways in all of the different agencies or departments that is covered by the union.
But have you had to pursue a grievance over those items before?
No.
Able to get it worked out one way or the other?
They all had understandings, or people decided not to move forward with a grievance.
I'm going to ask you to go to Exhibit J in the notebook in front of you. Can you tell the board, Personnel Policy Board, what Exhibit J is?
It is the Personnel Policy Bulletin for Inclement Weather Closure and Emergency Declaration Policy that was approved August 15th of 2023.
And would you agree that that has not been approved by the county board as a policy that would apply to you?
This one was back in August 15th, 2023. This was the inclement weather bulletin they put out. It's not part of the personnel rules and regulations, but it was a bulletin.
And if you go to page F, page 2, paragraph F.
Oh, this has got the, so this was what was sent. I'm on the Employee Advisory Committee for, they've got a group of us because one of HR's projects over the past year was updating the policy rules and procedures to make recommendations to you guys. And this one was sent to me at the beginning of May. I know it was after Mary had left, but before Jody joined us, that it was sent out in a group of things for us to discuss. And it's just it's got some, what they were recommending as updates to the weather closure policy.
So this was a proposed change to the policy.
Yes, but has not been approved by the board.
And it
Sorry.
was- okay.
That approved by the board thing at the top confused
And-
me is what I was looking at.
All right. And you said that it was sent to you in May. Was that in May of 2025?
Yes,
So after these grievances had been appealed, you received a proposed change to the policy, which included this new language.
yes,
And if you look at paragraph F, the proposed change would be that if there is not a severe inclement weather closure and an elected official or department head makes the independent decision to close their office due to inclement weather, employees will be required to utilize their accrued paid leave, right?
yes,
Isn't that what the Treasurer Mixell was saying today, that he thinks that's what the policy is?
yes. But this one has not been put through.
And paragraph E added, the proposal that you received from the county HR office was to change that to read, if, instead of just county offices, if all offices are closed at the direction of the county board, that this new language that they were suggesting should be added, right?
Yes,
And would you agree that if this language was added to the policy, then the existing policy would not be, it's not something you would grieve,
no. This-
based on
it's a lot
the events of
clearer.
March 19th?
Yes,
But based on the current policy, it doesn't prevent the elected official from closing the office, does it?
no,
And the contract says that the elected official is supposed to set the hours.
correct. And even then, if this was in the policy rules and procedures, our contract supersedes what is here as long as it's not illegal in some respect. So that would still apply.
Or in conflict.
Yeah,
If the contract is in conflict with the policies, the contract takes precedent over the policies.
right.
All right. Those are the questions I have. Thank you.
Mr. Kuhnhart?
Yes. Ms. Ernst, if you could look at Exhibit A.
Yes.
The contract.
The contract?
Yep. So if you go to page 8, I'm in Article 9.
8?
Yes, correct. Page 8, Article 9.
Okay.
So if we look at Section 1 of Article 9, it says that the section is intended to set forth a normal work week, correct?
Yes.
And then if you go to the third paragraph in that Section 1, it talks about what a work week is and that office hours are determined by the elected official, correct?
Yes.
And this Article 9, hours of work and overtime, does not mention anything about inclement weather, correct?
It does not.
And on March 19th of 2025, the county board chair did not implement a severe inclement weather closure, correct?
Correct.
And only the county board chair has the ability to declare a severe inclement weather closure. Is that correct?
Correct.
And if we looked at Exhibit J, which was the proposed policy. Do you remember looking at that with Mr.
Yes.
Corrigan?
Yep.
That was not the policy at the time these grievances were filed, correct?
Correct. It was not.
So it's not relevant to any of the grievances that are being heard today. Do you agree with that?
Objection, foundation.
No, I don't agree with that because the policy that is currently in place is unclear in many respects.
Well, let's look at that policy. So let's look at Exhibit 1. Do you have that in front of you?
I do.
Okay. And we talked about this a little bit ago. So if you go on the first page to section B, severe inclement weather closure, do you see that? Mm-hmm. Okay. And B2 says the county board chair shall have the discretion and authority to implement a severe inclement weather closure, correct?
Yes.
And earlier you agreed that did not happen on March 19th of 2025, correct?
Correct.
And if you go to the next page in section, we're still in section B, it's B5, little b.
Okay.
This is talking if there is, I guess you back up to 5. So B5, it talks about if the offices are closed due to a severe inclement weather, that employees would be paid, correct?
Yes.
But that's only in the event of a severe inclement weather day?
Objection, foundation.
You can answer.
My objection
Oh.
should be ruled upon, I guess, before the, I mean, he's asking her for a legal conclusion as to the meaning of the language.
Well, she was comfortable reading Exhibit J to me, so I think she can opine as to Exhibit 1.
I'm going to allow it.
I'm sorry, will you repeat it?
Yeah, I think my question was, we established there was not a severe inclement weather day on March 19th, correct?
Correct.
And that only the county board chair can declare a severe inclement weather day, correct?
Correct.
And that is the only way that employees would be paid under section B5B of the current, or the policy that was in effect on March 19th of 2025, correct?
Correct.
I don't have any further questions.
Do any of the policy board members have any, do you have a redirect?
Yes.
One moment. Go ahead.
Sure, the policy provision that indicates the county board chair has this authority doesn't say anything about whether elected officials also can close the office, does it?
It does not.
And the contract says in Exhibit 9, I'm sorry, Exhibit A, pages 8 under Article 9, that office hours shall be determined by the elected official, right?
Correct.
It also says employees shall report to work at a starting time and leave work at a quitting time as determined by the elected official, correct?
Correct.
So the contract gives the authority, at least under the union's perspective, to let the elected officials determine whether they will open or close their offices or require employees to work or not work.
That's my understanding.
And that's why the union challenged to determine not to pay these people.
Yes.
Those are the questions I have. Thank you.
Mr. Kuhnhart.
Nothing further.
Anyone on the personnel policy board have any questions for this witness?
I have one point of clarification, just to make sure I'm understanding. So if the contract and the policy are in disagreement, the contract supersedes a policy?
Yes.
Is that correct? In the eyes of the union? Is that what the contract says? I'm just making sure I understand that
Yes.
statement.
Yep.
That
Yeah, I can. It's in the contract in the beginning, at the start of it. Oh. It's in, I know that's in here.
Section 3, page 5.
Thank you for your assistance. Yeah. The positions of county elected officials have been created by an authority vested in such by the Nebraska legislature. Therefore, when in conflict with the personnel policy manual, such official authority provided not in conflict with federal and/or state statutes and this contract will supersede said manual.
Thank you for clarification.
Any other questions? All right, you may step down. Mr. Corrigan, do you have another witness?
I have no other evidence.
Thank you. Mr. Gunnar.
Besides what's been presented, I have no further evidence.
All right, Mr. Corrigan, you want to make a closing argument?
I don't know if you want me to stand up or come to the podium or what. I want you to hear me.
Whatever you want.
I guess the first thing I would suggest to you is I'm happy to make a closing argument. This is a legal question. There's really only, this one day of pay. We will know who should get paid by who was not, who didn't work that day. And what I would be happy to do, if you wanted us to, is submit a closing written argument with, a brief with some legal authority. Otherwise, I can talk to you about it. It may not satisfy you. I have had other cases in front of similar bodies where we would submit a closing argument, and then the board would continue the hearing and come back and decide it after the briefs were submitted. I'm happy to do that. I'm also happy to just make a closing oral argument to you at this moment too. Either is fine, but I just throw that out as an option because there are facts that are important in this case, but it is ultimately a legal issue. So if you want me to do that, maybe at the close of our arguments, if you could discuss it and you want legal written briefs, be happy to submit that to you. The policy at issue, Exhibit B that was offered by the union, or Exhibit 1 that was offered by the county, it clearly doesn't prevent the elected official from closing their own offices. It says that the county chair shall have the discretion and authority to implement severe weather closure, but then it also says if county offices are closed due to severe inclement weather, the following procedures shall apply, and those folks are to be paid. If the employees who are not required to report to work shall be paid for the inclement weather closure period at their regular hourly rate. Now, in this case, there was a communication that went from the treasurer saying, we're closed today, see you tomorrow. And we know it was a bad weather day because the county board, under the resolution, which is in evidence in Exhibit I, on April 1, on April 1st, 2025, adopted a resolution approving the retroactive disaster declaration due to severe weather in March of 2025 because of the March 19, 2025 date. It was bad, and people didn't come to work because they were told by their boss, we're closed today. And this policy is not all that clear. It's not as clear as what the county wants it to be. I mean, you have the appointed authority saying, we're closed today, see you tomorrow. The next day, he's sending an email saying, I'm sorry, I tried to get you HR administrative time, but they won't agree to it. The employee, then he tells them, and I agree that this makes sense, and I'm not saying that it's bad that he did this, but just think about it from the employee's perspective. You know what, going forward, this won't happen. They'll either close, or if I close, then it's PTO, but I'll give you a chance to come in and work more so you can make up the time that it cost you because I told you not to come to work. And if I'm having trouble coming to work because I got to take care of my kids all the time anyway, maybe coming in early and staying late is part of the problem. But be that as it may, I mean, that's the real world effects of what happened here. And to Mr. Mixel's credit, he gets the grievances from the employees, not just these 8, but all of the employees in the bargaining unit, and sustains them and says, yeah, you should get the remedy that you asked for. And then another meeting takes place, and we have him saying in Exhibit A, Exhibit G, upon further review, I've decided to withdraw my previous response and deny your grievance for the March 19 office closure. And the union's position simply is, there's 2 masters here.
Mr. Corrigan, you have 30 seconds left.
There's 2 masters here. And one of them's not the clock, but one of them is the elected official and the other is the county board. And the contract says that the elected official has the authority to set the working hours. He did it because of inclement weather, and they shouldn't be punished by losing 8 hours of pay because they followed the direction of their boss. It's that simple. We'd ask for the remedy, and I'm more than happy to submit a written argument to that effect.
Thank you, Mr. Corrigan. Mr. Kuhnhart?
Yes. Under the current policy, only the elected official can close the office, but under the policy, you have to have a severe inclement weather closure declared by the county board chair for the employees to get paid. That is the only situation when employees get paid under the current policy, is that the county board chair declares a severe inclement weather day. That did not happen on March 19th of 2025. I do want to address briefly Exhibit I, which Mr. Corrigan addressed, which was the disaster declaration that was made after the fact. If you look at the Sarpy County Board of Commissioners disaster declaration, it does not authorize or retroactively declare severe inclement weather closure. It does not authorize back pay. It only deals with storm damage to try to get the county funding to deal with what the damage that was done by the storm that day. The treasurer testified today that he was aware that his employees would have to use PTO under the policy, and that he did it for closed his office for the safety of his employees. When you look at the union contract, which is Exhibit A, Article 9 is simply it establishes work hours and overtime. So that says our work weeks during a 7-day period is going to be this, and office hours shall be determined by the elected official. It's simply irrelevant to the issue here today. I mean, what we're talking about today is the personnel policy regarding inclement weather closure and emergency declaration policy, which is Exhibit 1. One other issue, if you look at the evidence in front of you here today, you only have 8 grievances in front of you from 8 grieving employees. And those are if the board finds that relief should be granted, those are the only individuals that are entitled to relief. Article 24 sets forth a very specific procedure on how grievances are handled and how a grievance gets to the board today, and only 8 individuals did that. So in closing, I encourage the board to look at Exhibit 1. It's very clear that only the county board chair can declare a severe inclement weather day. That did not happen on March 19th of 2025. Therefore, the employees were not entitled to pay and had to use PTO. Thank you.
Okay. Any questions from the Personnel Policy Board? All right, we'll convene in closed session now. Do you want a motion? Motion, please, for closed session?
I'll motion.
I'll second to go into closed session.
Four yea, one absent, motion carries.
everyone. All right, first I'd like to ask for a motion to return to session.
So moved.
Second.
Oh, Carrie, should have checked if you were ready.
Okay, which one motion?
Davidson.
You.
Yeah.
Randy seconded, thank you.
Okay, and then we can vote.
Four yea, one absent, motion carries.
All right, and then I'll ask for another motion to vote on the grievance.
I'll make a motion to deny the grievance.
I'll second it.
Okay, call for a vote.
Four yea, one absent, motion carries.
All right, Pam.
Yeah, okay, so just briefly, the Personnel Policy Board has asked me just to make a statement as this decision impacts several of you in the Treasurer's Office. Of prime importance is the fact that you all are a civil service county. And what that means is sometimes in order to ensure fairness and consistency, elected and appointed officials get authority removed from them and centralized with personnel policies, like what was presented in the bulletin. And of utmost concern with them is if the bulletin is saying the county chair has the authority to issue or implement a severe inclement weather closure, and that isn't upheld, and elected officials or appointed officials are able to implement this policy, which would trigger the pay, we would have significant inconsistency within the counties of who's going to close, who's not, who's looking out for safety, who's not, what department cares more about their employees versus others' departments. And that is of utmost importance to this Personnel Policy Board, saying this is why we have consistency. This is why we have one individual who can make this decision and implement it, because we want to ensure fairness. And fairness starts with the cornerstone of consistency. And so that was their request to give you some information about how they believe this policy implements that pay will only be done when the county board chair declares it. And it wasn't followed in this situation. And that consistency is the reason that today's decision has been to deny the grievance. Anyone here want to supplement what I've said? All right, you want to make a motion to adjourn?
To close the grievance hearing and then adjourn.
Okay, I'll ask for a motion to close the grievance hearing.
I move to close the grievance hearing.
I'll second that.
Okay, vote.
Four yea, one absent, motion carries.
And then do we have a motion to adjourn?
So moved.
Second.
And time to vote. All right.
Four yea, one absent, motion carries.
All right, meeting adjourned at 5:36 PM.
Thank you. Carrie?